Hi, everyone. We're going to go ahead and get started. Thank you so much for joining me for today's disability chat. I am the Senior Manager of Disability Programs here at HDSA, and my name is Allison Bartlett, Esquire. Today, we are discussing how to navigate the Social Security appeal process. And please do not hesitate to ask a question. It's easy to ask a question. You can just put it in the chat. All questions will be answered by myself after the presentation, but you can send your question at any point. Like I said, just click the chat function, type in your question, and your questions will only be seen by us at HDSA. And this presentation will be available in about a week on HDSA's YouTube channel or by going to www.hdsa.org/disability chat. Currently, there's tentatively placeholders for webinars coming in March and May. I just haven't exactly figured out what those are yet. Okay, so like I said, today we're going to be talking about how to navigate the Social Security appeal process. And this is going to be more of a high-level overview of everything to expect. If you're at specific parts in the appeal process, that's something you may want to have a one-on-one with me at another time. But today it's a high-level overview just to kind of understand how the appeal process works within Social Security and all the different levels. So we're going to talk about the appeal cycle, appeal basics, reconsideration, administrative law hearings, appeals council, federal court, and best practices. So what do I mean when I say appeal cycle? Well, I call this an appeal cycle because it works in a cyclical manner. Every case starts at the initial application stage, and then the second stage of appeal is reconsideration. Then it goes to administrative law hearing, to appeals council, and finally, for a few who are brave enough to try, federal court. At any point, you can hop out of this appeal process, appeal cycle, and start over. And so one of the things we're going to talk about today, when it really makes sense to start over, when it makes sense to follow through the process. But overall, this is how the appeal cycle works. This is always the order that the appeals work in. So clockwise from initial application all the way through federal court and back. And then I made this nice handy dandy infographic to kind of give a little bit more detail about what these processes look like, but just to put it in a nice image because it can really help to see things and see how they play out. And this gives a good idea about how long this process is going to take and how long appeals take and where you want to be in the process. And again, another thing we're going to talk about today is the benefits of appealing the process and going through it. Because yeah, this is overwhelming when you initially look at this and you see it takes 12 to 24 months just to get a hearing on top of the 10 months, possible 12 to 14 months, you've already been spent in this process. But it's important to understand the cost benefits to going through this process. And even though it can take time and that can be really scary and overwhelming, and there's a lot of stuff that goes on behind the scenes, why it's important to understand what the appeal process looks like, how long things take, and what are the benefits to appealing a decision. So first we're going to start with appeal basics. So in order to appeal a decision, your claim has to be denied. You cannot appeal a decision until you get a formal denial, and a lot of times this formal denial comes in the terms of a denial letter. Sometimes you'll get a call from Social Security, but the majority of the time you're going to get a denial letter. And this denial letter is really important because there's a lot of really important information in there about your denial and why you were denied. You should get a letter in the mail with details of your denial, but if for whatever reason you don't get a letter in the mail, it either gets sent to the wrong place, they have the wrong address, you should have a copy of the letter in your online account. Part of the reason this letter is so important is because there's going to be a date on the letter. The date on the letter is the start date for when your appeal time frame runs. And I'll talk a little bit more about that on the next slide. But when you get the appeal letter, or when you get the denial letter, it's going to be really easy to just read the first few sentences, see that you were denied, and get upset and not be able to read the rest of the letter. And that's okay. If you need to take an hour, 2 hours a day, okay. But at some point, you need to go back to this letter and you need to read through it. And the reason you need to read through it is because there's really important denial language in these letters. So, what does this language tell us? It tells us what kind of denial. With Social Security, you can either get a technical denial or a medical denial. A technical denial means you either are making too much money, you are working too much, you don't have enough credits, you have too many assets. If you have a technical denial, Social Security never looked at your medical records and the medical aspect of your case. If you got a medical denial, it means Social Security reviewed all your medical evidence and didn't think you were disabled enough. And this is important because this helps us figure out whether submitting an appeal is appropriate and what kind of appeal is appropriate. There's also going to be possible language that your condition is not severe enough, or while your condition prevents you from performing your past work, it does not prevent you performing other work. Or based on the evidence provided, you are not disabled from this date, before this date. And all of these things tell me, a knowledge disability attorney, a lot of information about why you were denied. So the middle bullet point, while your condition prevents you from performing your past work, it does not prevent you from performing other work. This tells me that of Social Security's 5-step denial, you were denied at step 5. So, with Huntington's disease, you probably should have been approved at step 3, but for whatever reason that didn't happen. And they took you through a step 5 analysis and they determined that you could do some random piddly job they found in Nebraska or wherever else in the country. So, what does that mean for your case, and how do we improve your case at the next level? And so, having these conversations and knowing what's in your denial letter, or at least having your denial letter so you can show to your social worker, to an attorney you hire, to your friends or family, you need to have it. You need to keep it in a safe place and you need to know what it says because it's so important for how you move forward. And I mentioned this briefly. So, another reason the letter is so important is because there's going to be a date on the letter in the upper right-hand corner. The date on the letter is the date your 60-day appeal window starts. This is a very strict deadline. This is a very strict deadline. So you want to make sure if you're going to appeal this decision that you get the appeal submitted within 60 days of the date of that letter. There is a limited exception. It's good cause for late filing. I'm including this in here because this is an overview of the appeal process, but this is not something you should rely on. It's hard to prove, and it adds a lot of time to your claim processing because you have to wait for Social Security to accept good cause before they even look at your claim. This could take 6 months or more just for them to accept good cause, which means nothing has been done on your case in that time frame. If you're going to file for good cause, you really need to have an attorney. And there are very specific examples that Social Security is looking for, like you were seriously ill and prevented from contacting Social Security in person, in writing, or through a friend, relative, or other person. Like a possible example of this is if you get hospitalized, your friends and family can't find you, and like either you're in a coma or you're mentally incapacitated at that time, but it rises to a very high level, or there was a death or serious illness, or records were destroyed. Like there are technically options, but you don't want to put yourself in this position because, again, this is going to delay the processing of your claim. If you already waited 8 months for a decision, you got denied, you missed a 60-day window, you could be tacking on another year before you get a decision on the appeal. And that's a personal decision, but you don't want to put yourself in that position and you don't want to have to ask yourself, is that worth it? So, what's the benefit of appealing? There are a lot of benefits. First, it protects your financial benefits through Social Security. And it gives you the best opportunity to get the most benefits possible. So, the longer you wait to file a Social Security disability claim, it means you could reduce your monthly benefit amount. Appealing a decision isn't going to impact your monthly benefit amount. It also is going to hold your benefit amount back to your alleged onset date. And this is always slightly confusing. Social Security pays benefits back to your onset date, not the date you submit your application, not the start date of certain things, but it's the onset date that you give to when your disability started. But you can't have an onset date if you don't have an application or appeal pending. And so if you start over, it means you have to change the onset date and push it to the future. Not appealing the decision keeps your original onset date. And again, if you get approved, while going through the appeal process, if you get approved and let's say your onset date was 2 years ago and then you finally get approved, you get past due benefits for all of that time. If you start over, you lose those past due benefits. So you're leaving a lot of money on the table if you don't appeal your claim. And a lot of times starting over won't fix your claim because a lot of individuals don't always understand the process of Social Security itself. So getting frustrated and blaming Social Security, but not understanding the process and not understanding what it takes to get approved and just filing new claim after new claim, that's not fixing the claim. And it's not giving Social Security what it needs. Appealing your claim gives you an opportunity to continue to add evidence and support so you can eventually get approved. There are a few times when an appeal may not be appropriate, and some clear instances of this is if you were denied for working over substantial gainful activity. That amount in 2023 is $1,470 per month. Let's say you're making $3,000 a month with no accommodations, you're not going to be able to appeal that. There are a few exceptions. I'm not really going to get into it, but if you're very clearly working and it's well over the SGA limit, you just need to stop working. And then the date you stop working officially will be the date of your onset date. And you can possibly get denied for having too many resources. So really this is applicable to supplemental security income or SSI if you have over the $2,000 resource limit as a single individual or over the $3,000 resource limit as a married couple. The exception to this is if you were under those resource limits and for whatever reason Social Security was missing documentation, that's a different issue. But if you're very clearly over the resource limits and you don't have a reason as to why you are over the resource limits, then you just need to submit, you just need to start over. So the first stage of the appeal process is reconsideration. So they're reconsidering your claim. And this is a paper claim, and it's very similar to the initial application. You complete an appeal, it's either online or in person, and the decision is based on your medical evidence, your appeal paperwork, and your written evidence. So when I say paper claim, it means Social Security is not going to see you. Everything is based on pieces of paper you submit to Social Security. This is the hardest stage of the process to get an approval, in part because it is reviewed by the same office. Less than 10% of cases are approved. But if you think about it, you're asking the same people who already reviewed the case to look at the case again and hope for a different outcome. Social Security is not going to admit fault unless there was clear fault or missing evidence. So there's a pretty high burden. You either go in knowing like they're likely not going to overturn this because my case was super strong in the first place and they messed up, but they're not going to admit it. Or what did I leave out and how do I fix it? Traditionally, the average time for a decision at this process has been about 4 months, but wait times have gotten a lot longer in most states post-pandemic. I haven't found a good average, and some decisions have taken up to 12 months. It's really hit or miss. Again, Huntington's disease falls on the compassionate allowance list, which is supposed to expedite your claim and make sure your claim is looked at more often and supposed to get pushed through the system faster. That's hit or miss, and you need to make sure you're constantly following up with Social Security to make sure they correctly flagged your claim. So I'm going to talk about burden of proof because this is a really big deal with Social Security disability, and a lot of people don't understand the burden of proof, and so I'm trying to shift that conversation. When it comes to a Social Security disability claim, whether it's SSDI or SSI, the burden of proof is on you. It is your responsibility to show that you are disabled. You have to provide medical records and other evidence. You have to answer questions honestly and with lots of detail. That means you have to answer everything fully and completely on the appeal paperwork and any other forms that Social Security is going to send you. Social Security is likely going to send you the exact same forms during reconsideration that they sent you during the initial application. So it means you're going to have to complete an updated adult function report. You might have to submit another work history report, but they like to send out the same forms in both the initial application and reconsideration. You have to make clear that you are disabled due to your HD and you cannot work. Social Security's job in this process is to review the evidence. It is your responsibility to provide the evidence and paint a very clear picture as to why you are disabled. And there's still misconceptions in the HD community and with Social Security in general that if you have something as severe as Huntington's disease, you're just going to automatically get approved, or that compassionate allowance means you get automatically approved, and that's not right. You have to show the burden of proof. And in some ways, having the burden of proof is higher in the HD community because HD is not well understood nationally, and it's not well understood by Social Security. And so you have to make sure that you're very clear that you have adult onset Huntington's disease, what that means, and how it impacts you on a day-to-day basis. So what are things you can do to improve your chances for approval at reconsideration, especially since chances aren't great to begin with? In a lot of ways, I think reconsideration is in this appeal process just to frustrate people. Social Security literally had a review a few years ago to decide if they wanted to keep reconsideration, and they're like, well, it benefits 10% of people. If any of it, with anything else in life, please, please show me if anything else has gone forward because it only benefits 10% of people. So I think this is kind of built to be frustrating so people don't move forward through this process. But what I want to make clear is reconsideration is supposed to be a little bit frustrating. I think it's there in some ways to disincentivize people from moving forward. Know that as you move through this appeal process, like this appeal process, reconsideration specifically, it's just going to be a little bit frustrating and annoying, but you have to do it so you can move forward. But to give yourself the best chance for getting an approval at this process, because it is definitely possible, you want to make sure if there's any evidence missing from your initial application, and that would be included in your denial letter. You want to know if anything was missing, you need to submit the missing evidence. You also need to submit any new medical evidence. So let's say you get like neuropsych testing done or some kind of cognitive testing that shows like a clear progression in your HD or shows that something was missing in your initial application. That is really strong evidence that could really help you get approved at the reconsideration level. Or let's say you get functional testing done and now you have a really clear idea of your physical limitations, or you get physical or occupational therapy evaluation, or you get a speech evaluation done. All of those things are really important to Social Security, and they can change the outcome of your reconsideration appeal because they can show progression. It's like substantive evidence that can really change the outcome of your case. Another thing that can really help is submitting letters of support from friends and family, and I didn't include it on the slide, or a letter of support from your neurologist. Those are also really good pieces of evidence, and they can change the outcome of your case as long as they're detailed, they're thorough, and they really describe what you're going through because of your HD. And really the big one, you have to clearly show how your HD has progressed. So the reconsideration appeal itself will ask for changes since your denial, but you want to include all your symptoms and limitations because HD doesn't just like get worse overnight. You don't always necessarily recognize a huge change in a 2 or 3 month period. And so in order to like fill up the application, use all the space that's given to you, it's just better to include all your symptoms and limitations, regardless of when they started. If something gets a lot worse in a short time frame, highlight that, but talk about all of your symptoms and limitations because you're experiencing all of those things and those are all impacting you every single day. And you don't want to leave any blank spaces on an application. You want Social Security to know everything you're going through. So let's say you've gone through the reconsideration process and you get denied. You're kind of expecting it because of the process. Now you're at the administrative law hearing stage. So to request a hearing, it's another paper appeal application. You complete it online or in person, just like you do with reconsideration. It's actually the exact same online appeal. The one difference with this is you have to check a box to request a hearing before a judge. And you do want to have a hearing before a judge. And so this is going to be a hearing before an administrative law judge. They only hear SSDI and SSI claims. Their specialty is the Social Security process. And this is the best chance for a claim approval is at this stage of the process. Um, Honestly, like, especially if you go in with representation with an attorney, your chances of approval are in like the 60% range, which is significantly higher than any other stage of the process. So while reconsideration is frustrating, going through reconsideration is worth it to get to this stage of the process because this is the best chance for you to get an approval. And I know it's scary because it's a hearing, but what do you expect if you're at the hearing stage of the process? Well, you're gonna either have a hearing in person or by video. Video hearings are a lot more common now thanks to the pandemic. And so if you live far away or getting to the hearing is just not realistic, you can request a video hearing and they're a lot more accommodating. It's important to note that these are small hearings. If you're picturing something from like Law and Order or other legal shows on TV, that's not right. These hearings are held in tiny little rooms. There's only 4 or 5 people in a room. There's the judge, the vocational expert, and a lot of times the vocational expert actually testifies by phone. Their role in the hearing is to testify about your ability to do your past work and any other work. There's a court reporter, there's yourself, and there's your lawyer. A lawyer is non-negotiable at this stage. A lawyer gives you a significantly higher chance of getting approved, and this is a hearing. And like most likely, you are not a legal professional. You have never appeared before a judge before. You don't know how to ask yourself the right questions. You don't know how to cross-examine the vocational expert. You need a legal advocate. This is going to be a stressful process. No matter how much preparation and assistance you get, every single client I represented was so anxious when we got to the hearing. Even after practicing questions, preparing, knowing what to expect, it's definitely a stressful day. So you want someone there who's just there to advocate on your behalf. Sometimes the judge will let a family member sit in the hearing. The family member is not allowed to speak. The only exception is if your lawyer calls them as a witness, but if they're being called as a witness, they can't sit in the hearing with you. And these hearings typically last 15 to 60 minutes. What to expect continued. The judge and your attorney will ask you questions about your HD and any other conditions you may have, like what symptoms do you experience? How does HD impact your ability to work? How does HD impact your daily life? How does HD impact your ability to complete chores? And they won't ask those specific questions, but those are like the topic areas they'll ask you questions in. And then once you've testified, once you've answered those kinds of questions, the judge and the attorney will ask hypotheticals to the vocational expert about what jobs exist across the United States and if you could do them. Really, your attorney is there to present hypotheticals based on your symptoms and limitations to get the vocational expert to say you couldn't do any work. Because in order to be found disabled, you have to not be able to do any work. And the nice thing about the hearing is this is finally your opportunity to tell your story about how HD impacts you. The other parts of the process, the initial application, reconsideration, at this point, it's just pieces of paper. But this is your first opportunity to actually be in the same room with somebody from Social Security, to look them in the face, to tell them your story, to let them see how your HD impacts you. And one thing to mention about the hearing, like they want to make sure that you are comfortable. If you need water, you can get water. If you need to take a break, you can take a break. If you need to go to the bathroom, you can go to the bathroom. This hearing is for you. This is your case. This is your disability claim. The day is about you. So there is power in that. This is the first time you really feel empowered in the process. It's a lot. It can be anxiety inducing, but these are some of the benefits of going to a hearing and why it's worth waiting for this process. And you, and really your attorney, would make sure no medical evidence or other relevant evidence is missing from your claim before the hearing. What makes a hearing special is it's a de novo decision, which means it's a new decision. The judge is not bound by prior decisions. The judge reviews all evidence and makes their own decision. They are not bound by what the lower parts of Social Security decided. The one downside of an administrative law hearing is it usually takes 12 to 18 months to schedule a hearing. If you are represented with an attorney, your hearing will get scheduled faster because if you have an attorney, you will show up to your hearing. And then generally it takes 4 to 8 weeks to receive the written decision. You are not going to receive the decision the day you go to the hearing. The judge, a lot of times, once in my entire career, I had a judge make a bench decision and write the decision right then and there. I did have a few judges give my clients positive affirmations and allude that they were going to approve them, or they told them that they were going to approve them, and this is what the decision would say. You would still have to wait for the decision for things to be official. And it's important to know that all the hearing stuff is processed through the Office of Hearing Operations. The, the OHO. There are 163 hearing offices across the country, and if you want updates on your hearing or your claim that's at hearing, don't call the field office. You have to call the Office of Hearing Operations for updates. The field office has no idea what's going on in your case if you're pending before a hearing. There is a way to help get your decision pushed through faster. And again, this is made more possible if you have an attorney. They have something called an on the record decision. And this is approval based on paper evidence in the claim. So it means there is no hearing, and either the judge or the hearing office, there's attorneys in the hearing office, review the claim. And if there's enough evidence that they find favorable, they can approve the claim on the record. You will never get a denial without a hearing, but you can get an approval without a hearing. And you can request an on the record review, and it will not impact the outcome of the claim if it goes to hearing. Like asking the attorneys in the office or the judge to look at it before your hearing is not going to have a negative outcome on your hearing. And there were definitely times when I was representing HD families that offices went through claims on their own and then reached out to me and be like, hey, we were reading through your case file. We're pretty sure this person should be approved. They may ask me to do something or get my client to sign something, but an on the record approval is definitely a possibility, but it is made easier and more possible if you have an attorney. Another thing that might happen at the administrative law hearing level is you might get a partial approval. So what does this mean? Partial approvals that I've seen is that somebody had both an SSI and an SSDI claim. Their SSI claim was approved, but their SSDI claim wasn't because their credits had expired and they went too far back. Or a judge will find a person meets the medical criteria for disability, but not the technical criteria. So in this case, somebody is medically approved for SSI, but they might need to get their financial information in order to start receiving benefits. And another thing that happened a lot with HD families is a judge would want to change the onset date. So the onset date is a start date of a disability. A lot of times people would put the day they stopped working. A lot of individuals with HD stop working before they get a diagnosis. If you have no medical evidence or no diagnosis, or if you don't have enough medical evidence based on the date you chose, Social Security can't find you disabled, but they may go to you and be like, okay, you said you were disabled as of January 1st, 2019, but you didn't go to the doctor until October 10th of 2020. And there's a lot of information then, and there's a lot of evidence then, but there's nothing back to January 1st, 2019. We will approve you for benefits if you agree to change your onset date to October 10th of 2020. And that is something I definitely saw happen. And that's honestly a conversation you would likely have with your attorney before you ever get to the hearing to know that that's something to be expected, but that's something that comes up. And I know that's a personal choice. Like it's hard, but you have to recognize this is a federal process. This is federal law. Something like, is it worth continuing to fight? Is it worth is it worth risking benefits? Like it's an all or nothing proposition. So that's something to think about. But that is something that happens at hearings. Like there's more flexibility at the hearing stage because you're having a conversation in a room with the person who's going to make the decision in your case. You don't get that at the lower stages of the process. So what happens if you are not happy with the outcome of your administrative law hearing or you outright get denied? The next stage of the process is appeals counsel. So this is going back to a paper claim. You complete appeal paperwork online or mail the appeal request directly to the appeals counsel. So before you used to have like some connection with either your local field office, now you're going directly to the appeals counsel. You will not communicate with or appear before the appeals counsel. It's kind of, if you remember, like civics from high school, the appeals council in some ways works kind of like the Supreme Court because the appeals council decides if they even want to hear your case, just like the Supreme Court does. And they don't have to give you a reason why they're going to hear your case or not. They just let you know at some point, we've decided to hear your case. We haven't decided to hear your case. We're upholding the judge's decision. And when you appeal to the appeals council, you have to state why the judge's decision was incorrect. So what is the appeals council? It's a review board made up of 70 appeals judges. And this council has two jobs. They're quality review. They'll pull cases at random to make sure the law was upheld. One of my clients, their case was pulled at random and reviewed. And so we had to go through this whole process, which was kind of frustrating, but it happens. And then the other thing that they do is they review appeal requests. In some ways, appeals counsel is almost more difficult to deal with than the reconsideration stage. And the reason for this is it's very difficult for them to actually select your case, and they're almost impossible to communicate with and get claim updates. So you're just kind of be in limbo for a while. So the appeals council reviews less than 15% of cases, and most ALJ denials are upheld. Of the case, so they can either uphold a decision, change a decision, or completely overturn an ALJ decision. They very rarely overturn a decision. Less than 3% of cases are overturned. Most of the time, if they want to make a change, they'll remand the case back to the administrative law judges for a new trial or a follow-up trial to fix any issues in the case. The only way the appeals council does this is if there is an abuse of discretion by your judge, there's an error of law, the hearing decision is not supported by the evidence, it's a broad policy that may affect the general public, or evidence is found that existed at the time of your hearing, but for whatever reason wasn't available and would likely change the outcome of the case. But there's also a lot of discretion in this, and having an attorney walk you through this process and help talk you through these things and know what they want to argue moving forward is going to help, because if you're going to appeal the appeals council, you need to have your attorney be the one submitting the appeal, because there are certain things that they need to say to make sure Social Security and the appeals council understands why your claim should not have been denied. This is not something you should be doing without an appointed representative. The timeline for appeals council, it can take a year just for the appeals council to decide to review your case. And so for most people, this means you wait a year for your denial to be upheld. So is it worth appealing to this stage? This is a personal choice, and this is a conversation for like you and your representative, but it depends on your wants and needs. It depends on the strength of your case and the medical evidence provided. And it kind of also depends on if this is an SSDI claim, a Social Security Disability Insurance, when your credits expire. Because if your credits are going to expire in 6 months and your options are to reapply or go to appeals council, and appeals council upholds the judge's denial and you miss your window, then you're never going to be able to apply for Social Security disability again. And the reason for that is at the hearing stage, there's something, bear with me, it's going to get legal, res judicata or collateral estoppel. You cannot adjudicate the same claim twice. So let's say you go to hearing, you allege that you are disabled for disability with an onset date of January 1st, 2022. You cannot go through this whole process, have your credits expire, go back and refile and say that you're disabled to HD with no new evidence with an onset date of January 1st, 2022. Something is going to have to change. The lower levels of Social Security will let you go through it, but if you get to hearing again, the judge will likely throw out your case or say, we can't approve you because of these standards. And so again, this is why you want to have an attorney to walk you through this process. And then the appeals council is the last stage of the Social Security administration process. If you're not happy with your appeals council outcome, the next step is federal court. And this is a completely separate system. This is separate from Social Security. Social Security is technically under the executive branch. Going to federal court is a judicial system review, which means you are beholden to all federal court standards and rules. And you have to have an attorney who is licensed to practice in federal court to represent you. And the fewest individuals throughout the whole Social Security appeal process pursue this option. And there's a number of reasons for that. Like a lot of people, it takes a long time to get to this point. A lot of people get frustrated by this point, or they can't go this long without working. There's a lot of reasons people don't get to this point. Um, One nice thing about going to federal court is the court will give you independent perspectives on how Social Security applied rules and regulations to your case. So they're going to look at it from a different perspective. And good outcomes are more likely for those with strong medical evidence and who are treatment compliant. But one of the issues with HD is there is no treatment. So the treatment compliant part doesn't really come into play the same way. And so it doesn't mean that it's not worth going to federal court. They're just going to look at things through a slightly different lens because HD is such a unique condition. It is important to note that the chances of getting a good outcome are greater in federal court than they are at appeals council, but this takes an additional year to complete this process. So if you've gone all the way through this process, if you've gone all the way through the cycle that we've discussed so far, you're likely on year 3 or 4 of your original claim. And that's a long time to go without benefits. That's a long time to be stressed throughout this process. But again, this is a very personal decision. It depends on the strength of your case. It depends what you've experienced. It depends when you stopped working. It depends when you started getting medical care. It depends on the quality of your medical care. There's a lot of stuff that goes into this. So this webinar is not about, yes, you definitely need to appeal to all these things. It's just these are what these things are, and these are things to look out for. And at the federal court level, if you get denied, I mean, technically you can appeal the decision to the Supreme Court, but that's very unlikely that that's going to be accepted. So really, your option is starting over, which that's hard, and that's very frustrating at this point. If you've gone through this whole process and your claim is still denied, it's very, very frustrating. It's very, very frustrating, and there's not much else that can be said. But this is what the process looks like. So what are best practices? And this needs to be done from the beginning. Like when you're going through this process, you can beef up your claim, you can add evidence, you can do as much as possible, but sometimes there are some things that end up in your claim file that no amount of good work from yourself, your neurologist, or your attorney can undo. And so that's really hard. When we're talking about appearing before judges, judges are humans. You can have a really strong case, but we cannot predict what a judge is going to decide or how they're going to interpret evidence. I have seen judges get hung up on really unfortunate wording in an adult function report from the initial application. Somebody was overly confident in their abilities, and they're like, I can do this, this, and this. 2.5 years later, finally get before a judge, and the judge is like, well, you said you could do this, this, and this, and because you said it, we're taking that at face value. I don't care what your neurologist put in your medical records. You said you could do this, so we're going to deny your claim. And you like, I don't want anybody to be in that position. Like, that's probably technically a thing where your attorney might be like, we're going to appeal this to appeals counsel because that's really discretionary and is not supported by evidence. But those things happen because we do not live in a vacuum. These claims don't happen in a vacuum, and we cannot predict human nature. So it's good to be aware of that. But when you start this process, as you're going through the appeals process, you want to make sure you have all the relevant and important evidence is in your claim. So that includes medical evidence, letters of support from friends and family, your work history, specific details about why you can't work anymore, all of it. You want to work with your clinical care team to get updated medical evidence to make the claim as strong as possible. I can't believe I didn't say this at any point in my presentation, but you need to be going to the doctor regularly and continuing to get care throughout this entire process. You need to tell Social Security every time you go to the doctor, whether it's a regular neurology appointment or you ended up in the emergency room for a car accident or pneumonia, or I don't care what. Anytime you go to the doctor while your claim is pending, you notify Social Security immediately. Not negotiable, you do it. And I know I mentioned this, you want to get support from friends and family throughout the process, whether it's physically being there for you, taking you to appointments, or getting letters of support. I have seen friend and family letters of support be the difference between an approval and a denial. I take these letters very, very seriously because friends and family can provide evidence that your doctors don't see, because you don't live with your doctors. You don't live with your clinical care team. You live with your friends and family. Be honest about your symptoms and limitations throughout this entire process. Social Security disability is a brutally honest process. You have to be brutally honest about what you're experiencing, or they're not going to understand, whether it's in writing at the initial application stage or it's in the hearing before the judge. And this is really important. Get legal assistance. Hire the appropriate attorney to represent you through certain parts of this process. Like, there are a lot of things that get technical, that require legal knowledge, and get to the point where you cannot navigate this on your own. Are there any questions? Okay, well, good thing I came with some questions. So I know I mentioned hiring an attorney. At what point do you need to hire an attorney? So realistically, it's like I said, it's non-negotiable. You definitely need a hearing once you get, or once you definitely need an attorney, sorry, once you get to the hearing stage of the process. Can it be really helpful to have an attorney at the initial and reconsideration application stages? Yes. The reason I'm wary to tell someone to definitely get an attorney at the reconsideration stage of the process is because you only have 60 days to get the denial, find an attorney to take your case, gather new evidence, and submit the appeal. That's a really small window. And it can be really hard to get everything you need done in that time frame. And like I said earlier, only 10% of less than 10% of reconsideration cases are approved. So if you can deal with it and find an attorney and get stuff done at the reconsideration stage, go for it. There's more time to find an attorney at the administrative law judge hearing stage. You don't have to have the attorney to submit the appeal. You have essentially you have time to find an attorney up until the hearing is scheduled. And so that gives you more flexibility in the process. But if this is something that stresses you out from the get-go and you don't know if you can manage it, then hire an attorney from the beginning. But definitely once you get to the administrative law judge hearing stage through federal court, you need to have an attorney who specializes in this area. Another question, when to start over? And I know I mentioned that a little bit as part of the federal court process. Technically, you can start over at any point. You can, if you get denied at the initial application stage, you can start over. If you get denied, when you get denied at reconsideration, you can start over. But as I mentioned in the beginning, it's kind of a cost benefit analysis. You have to weigh what you're going to lose. Because if you're starting over, you need to submit a different claim. So does that mean you have a different onset date? What has changed that is making this claim different? If the claim isn't going to be different, then you should not be starting over. There is an argument to start over at the hearing stage once you get denied because, and again, that's personal choice. It depends on where you are in the circumstances, and what evidence is in your claim and how things have played out. But a lot of people choose to start over at the administrative law judge hearing stage if they get denied because the thought of having to take another 2 years for appeals counsel in federal court is really daunting. And it's hard, but there were definitely families that I worked with who decided to start over after having a hearing. um, for those people who have raised your hand, please type your message into the chat box. This is because this is a webinar and not a meeting. I don't have the ability to give you the power to speak. But as I was saying, there's a number of families that I worked with who decided to start over after the hearing stage, and they were approved with that initial application. So it can be really hard to predict because of the human component within Social Security. But again, that is something that's personal to you. But in a lot of instances, it's better to continue appealing and then having a conversation. For most individuals, it's not worth it to start over after one initial application denial or after a reconsideration denial. And there is no limit to the number of applications you can submit technically you can apply over and over and over again. Social Security is not going to stop you, and there is no like you are not penalized for submitting multiple applications. But again, for most individuals, it is a better use of your time, resources, and a protection of your disability benefits to go through the appeal process. Uh, I know there are a few people who had questions. I don't know if people are able to use the chat box. Sorry. If you guys are having trouble getting your questions asked, please don't hesitate to contact me at my email, abartlett@hdsa.org, and I will respond to your questions whenever you send them to me. But if there are no additional questions for now, I would like to thank everybody for joining me for this presentation. If you have anything you need in the future, please don't hesitate to reach out to me, and I hope you have a great rest of your day. Thank you so much.